good afternoon, good morning, good evening, depending upon where you're watching from. We're so glad you're with us today. I am Janice Kaminer-Resnick, and I welcome you on behalf of our leadership team, which aside from me includes former Congressman Mel Levine and former Los Angeles County Supervisor Zev Yaroslavsky. Welcome and many thanks to Erwin Chemerinsky as one of this country's most renowned constitutional analysts. We are looking forward to hearing his thoughts about the state and stability of our Constitution in the current time. There is certainly a glut of issues and cases to discuss, so fasten your seatbelts. It will be quite the hour. And of course, thanks and welcome to today's moderator, the outstanding Larry Mantle. Next week, we welcome Michael Posner, who is an ethics scholar and who teaches business ethics and human rights in the context of our global economy at New York University's Stern School of Business. Mr. Posner was an Assistant Secretary of State for Democracy under President Obama and has been a trailblazer in the domain of democracy, ethics, and human rights. The following week, on March 12th, we celebrate the end of our fifth year of America at a Crossroads with our annual anniversary guest, Jennifer Rubin. Jennifer Rubin was formerly, of course, with the Washington Post, but is currently one of the founders of The Contrarian, a very feisty and bold site with lots of impressive contributors. It resides at Substack. If you haven't looked at it, you really should. She started the site with Norm Eisen, who has also spoken several times to this audience. We'll finish off the first quarter of 2025 with Susan Glasser one week and Harry Littman the next. So we have a great lineup for the rest of March and then into April. As always, we thank you for joining us and for your commitment to staying informed and engaged. It's more important now than it ever has been. Look at the bottom of tonight's email. You'll get it right after the program ends to register for all of our upcoming programs. Now, please welcome today's moderator, the iconic Larry Mantle. Larry is the host of Air Talk on NPR's LA affiliate, LAist. His show has been on the air for, I think, almost 40 years and is part of the daily diet of a huge number of Southern Californians, including myself, and I know Mel and Zev as well. Larry, you are always outstanding, and we are blessed with your commitment to America at a Crossroads. The show is yours, and we are very grateful that you're here. Larry.
Janice, thank you so much, Mel and Zev. I appreciate all the support. And it feels like it's been too long. It's wonderful to be back on America at a Crossroads. As you mentioned, I've been doing my daily radio program, Air Talk, for 40 years. So this anniversary year has been very busy with a number of live events. And it's just great to be back for America at a Crossroads, particularly with Dean Erwin Chemerinsky. We go back to his days at USC's Gould School of Law, through his 4 years at Duke Law, his founding of UC Irvine's Law School in 2008, where he hired a remarkable group of professors for a new law school. It was really amazing, the casting of that law school that he put together right from the very start. And of course, his leadership of UC Berkeley Law starting in 2017. Dean Chemerinsky is a regular op-ed contributor to the Los Angeles Times, author of numerous influential and highly regarded books. He's argued before the U.S. Supreme Court. He's unfortunately endured high-profile anti-Semitic attacks in the past couple of years, something we all wish was not part of the extraordinary experiences he's had in his lengthy career. There's much more I could say about Dean Chemerinsky and the regard that I have for him, but there's a good chance you've heard him as a part of America at a Crossroads or the many other public venues at which he's spoken. And so I will leave his introduction at that. Dean Chemerinsky, always a learning experience to talk with you. Thank you so much for being with us this evening.
Thank you so much for that incredibly kind introduction. It's always wonderful to talk with you and always terrific to be part of America at a Crossroads.
Well, our theme this evening is whether we're facing a constitutional crisis with the barrage of executive orders and unilateral administrative branch actions that we're seeing in the second Trump administration, and whether the president might refuse to comply with court rulings against the moves he's making. Erwin, let's start with a bit of history here, because I think it's important to have context on where we are. So we have had presidents who have pushed the envelope of have attempted to buck the courts. I mean, Andrew Jackson, FDR wanted to pack the courts and had a contentious relationship with the federal courts. But what do you see when you compare what we're seeing in this Trump administration with some of the previous, benchmarks of antagonism with the courts?
I think it's so important to emphasize we've never seen anything in American history like the last month. No president has done so much that's clearly unconstitutional and illegal as we've seen in the executive orders from Donald Trump. And in terms of what you point to, the contentious relationship of other presidents with the Supreme Court, there's a difference. Franklin Roosevelt was very angry at the Supreme Court for invalidating New Deal legislation, but not once did he suggest he would disobey court orders. Harry Truman was upset with the Supreme Court when he wanted to seize the steel mills during the Korean War, and the Supreme Court said that was unconstitutional. But immediately, Truman had his Secretary of Commerce, Eugene Sawyer, give back the steel mills. Richard Nixon wanted to keep his White House tapes secret. When the Supreme Court ruled they had to be turned over to the court, Nixon complied, albeit reluctantly. Even your example of Andrew Jackson, who's quoted as saying, John Marshall made his ruling, let him enforce it. First, no one's ever proved Jackson actually said that. I think it's apocryphal. And second, Jackson never disobeyed a court order. What makes this so different is the quantity of unconstitutional legal acts and also having a president and vice president say, we don't need to follow what the courts order. Donald Trump, a week ago Sunday, specifically said, if one is saving the country, can't violate the law. That's not true in the United States, where under the rule of law, no one, not even the president, is above the law.
I was just talking on my radio program today with a pair of legal reporters, one from the New York Times, the other from Reuters, and they were making the point that in the actual courtroom where the administration is arguing for the latitude to do this, it's very different rhetoric than what President Trump is using in the public sphere. That it's, very, no one's saying like they're not going to listen to the court. They're very deferential, in fact, and are making the case for why this is within the realm of the executive branch's rights to do this. When push comes to shove, do you think that President Trump would really just say, I'm just going to totally ignore a high court order and order the people that work for him to carry that out? And then do you think that public employees would carry out those orders? Would that actually go into action?
The only answer one can give at this moment in time is there's no way to know that. My hope would be that when the courts issue orders, President Trump will comply with them. Every other president has. That's what the rule of law is about. But the rhetoric is troubling. Also, there are some examples that are troubling. On January 17th, the Supreme Court unanimously upheld the federal statute that prohibited TikTok from operating in the United States. It was supposed to go out of existence on January 19th under the terms of the federal law. Donald Trump issued an executive order that said TikTok could continue to exist for 75 days. He had no authority to do that. He was ignoring the Supreme Court ruling. Well, another example. Some federal judges have issued orders that funding that Donald Trump stopped had to be resumed. One federal district court in Rhode Island said that the Trump administration was not complying with the order. Another federal judge just yesterday found that the Trump administration was not complying with the order to resume funding of the United States Agency for International Development. He gave the Trump administration to midnight tonight to comply with his order. We should pay attention to that. Now, again, I'm not saying that the Trump administration will necessarily disobey what the courts say, even most of it. I'm just saying it's enormously important, and there are some troubling signs.
So, Erwin, how is what Trump did with TikTok's a great example of that, different than President Obama saying Congress isn't doing anything on immigration? I'm going to unilaterally set up DACA. How is it different from after the courts kept turning Joe Biden away from forgiving student loans, that he kept trying new routes and then had another one that he put out just, at the very end of his term, which has since been invalidated. We have all these recent cases of presidents trying just unilaterally to do stuff, either because they don't like that Congress isn't doing what they want them to do, or they just think it's of a moral high ground that, they should find a way around a court ruling. How is this different?
It's enormously different because what President Trump is doing is violating the law. Let's take spending and then compare it to your examples. There's a federal statute, the Impoundment Control Act of 1974, that says that when Congress appropriates money by statute, the president is obligated to spend it. In fact, even before this statute, many courts said when Congress appropriates money by statute, the president doesn't have the power to choose not to spend it. Congress has the power of the purse. President Trump has violated the Empowerment Control Act and separation of powers by refusing to spend billions of dollars appropriated by Congress by federal law. Now compare that to your examples. When it came to President Obama and DACA, what President Obama said is, there are 11 million undocumented people in this country. We don't have the resources to try to apprehend and deport all of them. We're going to set priorities with regard to enforcement, and we're going to not deport those who are children who arrived who don't really have a place to go. This is classic prosecutorial discretion. Possessing a small amount of marijuana violates federal law, but the federal government has chosen not to enforce that law. President Trump can choose what criminal statutes to enforce or not, but that's very different than choosing not to spend money. And your example of President Biden and student loans is a sharp contrast. There's a federal statute called the HEROES Act that said that the Secretary of Education is allowed to, and specifically it says, to forgive student loans or to excuse payment of student loans in an emergency. President Biden claimed that he had the authority under the very text of the statute to be able to forgive the repayment of student loans. The Supreme Court in Biden versus Nebraska, June 30th, 2023, ruled against him, and the Biden administration complied with it. They then looked for other ways under the statute to forgive student loans. When courts said they couldn't, they complied with it. But there's a huge difference between looking for statutory authority, which is what Biden did in that instance, and violating explicit statutes, which is what Donald Trump's doing in refusing to spend money.
But isn't the argument that the Trump administration is making is that the spending that you're referring to has to be carried out through something that's under the executive branch control? And so to some extent, even though the money is authorized and designated by Congress, that the executive branch has some degree of latitude because as part of its check, it's carrying out the actual spending through these departments that are under executive control.
Courts have consistently rejected that argument, and there's a statute that rejects the argument. Richard Nixon tried making that argument. He said that he had the authority to refuse to spend money Congress appropriated and used the words that you did, that the president has to carry out the spending. Every court to rule on it, including the Supreme Court in Train versus City of New York, said that the president doesn't have the discretion to choose not to spend money that Congress has appropriated by statute. Congress then in 1974 passes the Impoundment Control Act to say the president has no authority to impound and refuse to spend money. 50 years have gone by. No other president has challenged that or tried to impound funds until Donald Trump. And so far, the federal courts have considered it, have consistently ruled against Trump and said he just didn't have that authority.
Do you think that if this gets to the Supreme Court, it likely would be in alignment with the lower federal courts, or is there a chance, given its precedents, that it might say it disagrees with the earlier precedent on this, that the president really needs to have more authority over the ultimate spending of this money? Congress doesn't have the right, unilaterally as Congress, to enjoin the president from controlling expenditures.
I think there are issues where Donald Trump is likely to win in the Supreme Court, and we can talk about some of them. I don't think that this is one of them, because under the Constitution, the power of the purse is given to Congress. The Congress isn't doing this unilaterally. When Congress passes a budget bill, the president can sign it or veto it. If Congress wants to, it can override a veto by two-thirds vote of both houses of Congress. What President Trump is claiming is that even when a statute was properly adopted, signed by the president, a president gets another chance at veto through impoundment. Just yesterday, a federal district court in Washington, in speaking of President Trump's impoundment, said that not only was it imprudent for him to do this, but it was clearly unconstitutional.
I want to go back to the example you were referring, I think, to the Cole memorandum about choosing not to enforce marijuana law unless there's some other superseding issue where state law is violated, at least as I understand it. So that's certainly clearly in alignment with what you're talking about, the kind of discretion that the Justice Department has. In the case of DACA, though, I just wonder if you can elaborate a little more because that didn't that go beyond just a selective enforcement? We're not going to deport people who came here when they were extremely young by undocumented parents. They're going to have protections. It codified that with an actual period of time where the protection would was guaranteed to them. So doesn't that go beyond just judicial Justice Department discretion?
If the president has the authority to say we're not going to enforce immigration law against a group, the president can codify it in a way to write assurances for them. President Trump could issue an executive order saying we're not going to enforce marijuana laws below a certain amount, codify that so everyone then can rely on it and have that quantity of marijuana. The fact that President Obama said clearly what the policy was going to be with regard to enforcement was to the benefit of everyone in the country, especially those who are beneficiaries. One thing to notice to this is that when President Trump, in his first term, tried to rescind DACA, the Supreme Court, in a case, it was Department of Homeland Security versus University of California, ruled that he had not followed proper procedures in doing so and reinstated DACA. There wasn't question raised as whether President Obama had the authority to do it.
Erwin, let's talk about news. Just before we started our program this evening, the Associated Press reported it had obtained an internal memo from the Trump administration disclosing that there will be a 90% cut of USAID's foreign aid contracts. 90% is the intention to eliminate it. Does the president have, in your view, any discretion at all to cut USAID spending, to change priorities of the department, or is all of that completely controlled by congressional appropriations?
Congress, by statute, created the United States Agency for International Development. Subsequently, Congress, by statute, funded the United States Agency for National Development. President Trump can't eliminate a cabinet department or an agency created by statute, nor can the president say, doesn't matter what Congress has said, I'm taking over the spending power and we're not spending 90% of it. And as I mentioned, just yesterday, a federal court ordered that the Trump administration restore the funding of those contracts by midnight tonight.
When it comes to President Trump, the administration determining international relations, does the president have more latitude there because of the need for someone to speak as a unified voice? I think, for example, the Republican senators who sent that letter criticizing the deal with Iran, the nuclear deal, for example, and how upsetting that was for people. So, does he have more latitude with that?
Absolutely. The president does have much more latitude with regard to foreign policy. I'm very dismayed by what he's doing as to Ukraine, but I can't question his constitutional or legal authority to do that.
All right. We're going to get to some viewer questions in just a little bit. Just want to remind you that in the Q&A at the bottom of your screen, you can put a question. Please include your first name. And if you don't mind where you're asking the question from, it's just nice to give a sense of place for those that are watching, not just across the US, but also around the English-speaking world. So probably beyond the English-speaking world. Just put that, if you would, in the Q&A at the bottom of the screen. We appreciate it very, very much. One of the arguments, just sort of for those who support a unitary view of the presidency, or certainly a more empowered, more expansive view of the presidency, is that the president is far more responsive to voters than courts are. You have federal courts, these are life appointments unless someone is impeached, or they die, or they retire. But voters don't have access to that. They're protected in a way that a president isn't. Do you subscribe legally to any of that idea that there is, in fact, more power to the presidency than is typically used?
Question the premise, a second-term president can't run for re-election. So I don't think a second-term president needs to worry in that sense of pleasing the voters for the next election. Also, what's important is that the Constitution is meant to limit what the government can do. It's meant to limit what the president and Congress and state legislatures and city councils can do. So the fact that it's popular doesn't make it constitutional.
All right. And so even with a second term president, though, he could theoretically be impeached, of course. And he was elected where the federal judges aren't. But you don't buy any of that argument.
Well, I mean, Supreme Court justices can be impeached and removed too. But in terms of the popular election of the president and Congress, of course, it's very important they're elected. But the reason we have a constitution is to limit what the government can do. The reason we have judicial review is to enforce the limits of the Constitution. Once a president says, I can do what I want because I'm popularly elected, and I don't have to comply with the Constitution and laws, and I don't have to comply with court orders, then no longer do we have the rule of law. And then we have what's called a dictator.
The Los Angeles Times was reporting right before we started our program this evening that the Trump administration, along with congressional Republicans, is going to try and block the California 2035 mandate that fossil fuel powered vehicles will no longer be sold after that time as new cars. And this gets into the issue of what latitude, of course, that California has to do that. What's your view of the administration's power in this versus the states?
And let me set aside, I think it is tremendously misguided to ignore the problem of climate change. And so rescinding these kind of regulations to try to lessen carbon emissions, protect the climate is tremendously troubling. But I'm here as a constitutional expert. The law is that if Congress chooses, Congress can preempt what state and local governments do. So if Congress were to adopt a law saying that California can't have these emission regulations, California law is then preempted. But I think it would take Congress to do that. And if there's no federal law to the contrary, then states can regulate on their own. The basic principle of constitutional law is that for Congress to act, it has to point to authority in the Constitution. And when it does so and acts properly, that's the supreme law of the land and it preempts state and local law. But in the absence of federal law, state governments can do anything that's not prohibited by the Constitution. So the bottom line answer to your question is if Congress wants to pass a law keeping California from doing this, Congress has that power. But the Trump administration can't do it on its own.
So, Erwin, then, let's talk about agencies here because the EPA, I know, has granted a waiver for California to have some of its own rules historically, but we have, the Supreme Court decision on the Chevron doctrine that came back, which said, no, the courts have a right to weigh in where the legislation is ambiguous instead of the people of an agency determining what's a reasonable application of the law where it's silent. The courts have the right to weigh in on that. So then how does that affect all these environmental, all these other things where federal government agencies have really been the arbiter?
Let me start with a specific point and then go to the more general. Where the agency has adopted a rule, the agency can change that rule, but has to follow proper procedures. So where the Environmental Protection Agency has adopted a rule to grant a waiver to California, the Environmental Protection Agency can change that, but it has to go through the proper rulemaking procedure under the Administrative Procedures Act. It can't do it immediately. It can't do it arbitrarily. Now the more general point that you raise, where there's an issue about the legality of an agency action, the question comes up, should the court defer to the agency? And you refer to the Chevron doctrine. It comes from a 1984 Supreme Court case, Chevron USA versus Natural Resource Defense Council, where the Supreme Court said if a statute is ambiguous and an agency is interpreting, courts should defer to that expertise. That case actually involved the EPA and the Clean Air Act. In Loper Bright Enterprises versus Raimondo on June 28th of last year, the Supreme Court overruled Chevron deference and said it's for courts to interpret statutes. They don't need any deference to agencies. And interestingly, while liberals very much criticized the decision at the time, it might now very much be used by liberals because what they'll say is courts don't need to defer to the Trump administration's interpretation of federal statutes.
Yeah, and so and of courts of course can weigh expertise as well. And the argument is that conservatives have had historically is that often the people that are the experts in the governmental agencies have a particular political orientation, and that's carried out. So their argument is that the courts would have an opportunity in a more balanced way to hear expert testimony and to make the determination on it. You have mixed feelings on that, or do you feel Chevron was rightly decided before this most recent June decision?
Since the New Deal in the 1930s, the assumption of law has been that Congress needs to give discretion to agencies. The agencies will use their expertise, and courts should defer to that expertise. The Supreme Court no longer buys those assumptions. And so it's limited the ability of Congress to give power to agencies. It no longer wants to defer to the expertise of agencies. And I tend to believe that there are really technical areas where the agencies are the experts. I want to tie this, Larry, to something you mentioned earlier, which is called the unitary executive theory. This is something that the Trump administration is using with a vengeance. They're saying there's one president and he's in charge of the entire executive branch of government, and that he can therefore fire the head of any agency. In fact, he can even fire civil service workers. Any limit on firing of agency heads or civil service workers is inconsistent with the unitary executive theory. To this point, the Supreme Court has never accepted the unitary executive theory. In 1935, the Supreme Court said Congress could limit the removal of heads of federal independent regulatory agencies. But this might be a place where the Supreme Court will reverse itself and Trump will win. The question will be, how far will the court go? Will it say just that Trump can fire heads of agencies, or that Trump can fire even civil service workers and that civil service is unconstitutional? It's a very frightening prospect. And I think what's wrong with it is the Constitution creates checks and balances. The Constitution is not about independent powers, but interdependent powers. And the Trump administration claim of unilateral authority in this regard is a very frightening one to me.
If the High Court said civil service protections are unconstitutional, the chief executive has a right to fire any employee within any of these government entities, would the employees who are then subject to that and lose their jobs, would they have a right, a standing to sue because they were guaranteed the civil service protections as a condition of their employment, right? So if that deal changes, wouldn't there be potential damages that those people could collect?
The answer is no for many reasons. Some of it is that the United States government has sovereign immunity and can be sued for damages only when it consents. And some of it is the Supreme Court would go so far as to say that the civil service law is unconstitutional, then the protections that they were relying on were also unconstitutional. But let's pause for just a moment and think about how radical it is. Civil service has existed since the 19th century. It's always been thought essential in order to have an expert workforce to attract qualified individuals. No president in history until now has tried to say that the Civil Service Act is unconstitutional, that he as president has the right to fire anyone who works in the federal workforce.
Erwin, one of the observations about what Trump is doing is that he is making good on promises that he made, that many of these things he argued in detail were things he was going to do early in his term. He was going to radically cut the federal workforce, dramatically cut foreign aid, and cut federal expenditures. That he was going to deport millions of people. We haven't seen that because logistically, obviously, it's a huge challenge to do mass deportations. He can say that, but actually making that happen is a whole different thing. Um, so for those who say, look, he said he was going to do this, he's fulfilling what he had promised. What's your response to that?
That doesn't make it constitutional or legal. And he, as the president, takes an oath to uphold the Constitution and laws of the United States. And where what he's doing is unconstitutional, illegal, the courts have to stop it, and he respect the orders. The fact that he promised to do unconstitutional, illegal things that elected doesn't excuse violating the Constitution and federal laws.
You might have seen in the New York Times, there was an op-ed that was written by two law professors, one from Georgetown and one from the University of Minnesota School of Law. It was on birthright citizenship. And so they focused on that key phrase, people subject to the jurisdiction of the United States government. And so the argument has been that if someone is born here, they are subject to the jurisdiction of the US unless they're the kids of diplomats, for example. So the piece by Randy Barnett of Georgetown and Ilan Werman of Minnesota argue that those who came here without authorization really haven't entered into the social contract that was historically understood as part of being subject to the jurisdiction of a nation. What do you think of that argument?
Judge Sugarman wrote a blog post in which he said, I'm an originalist, and the article by Barnett and Werman give originalists a bad name. One of my colleagues, who's a legal historian, Dylan Penningroth, said, this is the worst kind of historical analysis where they picked some examples and ignored so much on the other side. So my colleague Dylan Penningroth pointed to the legislative history of the 14th Amendment, where one senator said, does this mean that even someone from China as a child in the United States, their child would be a United States citizen even if they're not? And the response was, yes, that's exactly what it means. Indeed, the Supreme Court in 1898 in United States versus Wong Kim Ark said that everyone born in the United States is a United States citizen, regardless of the immigration status of their parents. And the Supreme Court in that case, over 100 years ago, addressed just the argument that you pointed to. The Supreme Court said within the jurisdiction of the United States was simply meant to mean if there was an invading army and a child was born, that child wouldn't be a citizen. If there was a foreign ambassador and a child, that child wouldn't be a citizen. Correspondingly, if we have someone in the military abroad who has a child, they're still a United States citizen. If somebody works in a foreign embassy, they're still a United States citizen because we're within the jurisdiction. Reputable legal historians say that it's clear that the purpose of this first sentence, Section 1 of the 14th Amendment, is anyone born in the United States, subject to the jurisdiction, the examples I mentioned, is a United States citizen.
Do you see any way in the world that the Supreme Court would undo birthright citizenship?
I don't. Again, as I said to you earlier, I think there are a number of areas where the Trump administration is likely to win in the Supreme Court. One of them might be with regard to the ability to fire at least high-level federal officials. But I don't see that the Trump administration is going to win on birthright citizenship. So far, four federal courts have ruled at the district court level and one federal court of appeals, and they've all ruled against President Trump on this. And the reason is the plain language of Section 1 of the 14th Amendment. The reason is the Supreme Court's decision from the late 19th century. And also the reason is that everyone has relied on this and it's always been understood since the 19th century. If someone's born in this country, they're a United States citizen. I don't see the Supreme Court overturning it. And no one even suggested until very recently that it was otherwise.
We've had a stay, if I'm not mistaken, on the implementation of the administration's doing away with funding and departments within the government for diversity, equity, and inclusion. And one of the arguments that people make who believe the DEI programs are harmful, but another argument is, the public never had a chance to weigh in on this. This is sort of, just adopted by these departments without really public input. Do you think that this is something where a president does or does not have latitude?
To start with, the president doesn't create conditions on federal spending. Congress creates the conditions on federal spending. To the extent that President Trump on his own is creating conditions, that exceeds his power. Second, with regard to the diversity initiative, as the federal district court ruled last Friday in Maryland, it's so vague as to what the executive order is prohibiting. What does it mean to say that college universities can't pursue diversity? The Supreme Court has limited what college and universities can do to achieve diversity. College universities are not allowed to give preference in admissions on the basis of race. But that doesn't mean that they're not allowed to pursue diversity in other ways. And so the federal court last week found that the Trump executive order here was unduly vague and also to the extent that it restricted speech violated the First Amendment.
And the order, if I'm not mistaken, you can elaborate on this, was not just explicit direct programs. For example, we're going to recruit in African American communities to diversify our student body, but anything that was perceived as a proxy for that, wasn't that also targeted?
Yes, though it was in a different document from the executive order. A week ago Friday, the Office of Civil Rights of the Department of Education issued a Dear Colleague letter. And in it, it said college universities cannot pursue diversity, that they can't use proxies for diversity, race neutral factors that might lead to diversity, and that they can't have affinity groups defined on the basis of race. This goes so far beyond what the Supreme Court has said, what Title VI requires in terms of recipients of federal funds not being able to discriminate based on race. To start with, the Supreme Court was quite explicit that college universities can pursue diversity so long as they don't give preference based on race. Also, the Dear Colleague letter that we're talking about said that college universities can't look at essays and applications in something as a way to achieve diversity. Chief Justice Roberts' majority opinion in Students for Fair Admission versus Harvard College explicitly said that college universities could look at applications to see how race affected a student's life in providing inspiration or overcoming obstacles. The Supreme Court has never dealt with whether or not race-neutral proxies are permissible. The court had the possibility to take up that issue last year in a case coming out of Richmond, Virginia, and denied review. So my point about the Dear Colleague letter is it goes so far beyond the law. And one thing that hasn't been picked up by the media enough is footnote 3 in the Dear Colleague letter says, this is not binding as law.
What does that mean?
What it means is we're giving you our opinion, but you're not bound to follow this letter. And of course, I think it had to say that because it was just the opinion of the Office of Civil Rights, the Department of Education. Their
So is
opinion
it
may
then
ultimately lead to the law, but they acknowledge that the letter itself has no binding legal effect.
so the Dear Colleague memo, is it meaningless? It's just, as you say, a statement of intent down the road, but meaningless today?
It's important because it reflects the attitudes of the Office of Civil Rights, the Department of Education. It controls federal money to education. It enforces Title VI, but college universities are not required to comply with the Dear Colleague letter. Footnote 3 says that explicitly.
Let me go to some viewer questions. Susan in Davis, just next to Sacramento. Do the courts or Congress have jurisdiction over Elon Musk, who's neither appointed nor elected, but attends cabinet meetings, as he did this morning, Oval Office meetings, etc.? What legal basis is available to remove Musk, if any? That's Susan in Davis.
It's a great question. Presidents have often had advisors who are not government officials, but I can't think of any instance in American history where somebody who was not a government official actually exercised so much government power. There was a hearing about this last week, and the lawyer for the government was asked, "What is Elon Musk's status? Is he a government employee? Is he a government official?" And the attorney for the United States couldn't answer that question. Now, Elon Musk seems to be exercising the powers of an office of the United States. Under Article 2 of the Constitution, office of the United States are supposed to be nominated by the president and confirmed by the Senate. Giving this much power to somebody who's unaccountable is very troubling. Larry, earlier you were talking about should we be concerned about the courts because they weren't elected. What about Elon Musk, who certainly wasn't elected to any office?
We have cases though where presidents, as you just said, they bring in unofficial people, maybe it's celebrities they're close with, or all they take input and all. So what's the distinction between someone who's like an unofficial advisor and someone who's doing what Musk is doing with Doge?
I think there's a difference between being an advisor and being a decision maker. Certainly, presidents can listen to advice from where they want, and Donald Trump can listen to the advice of Elon Musk. But Elon Musk seems to be exercising government power. If you remember the press conference that was held in the Oval Office, it was Donald Trump who talked about what he was doing. It's Elon Musk who seems to be commanding a whole fleet of people in terms of cutting government programs. Musk himself says he's doing this. So my answer to your question is the distinction between advising, which isn't constitutionally objectionable, and being a decision maker, which should be exercised by those who've been properly elected and appointed.
Joan asks, how does the president have the authority to tell New York City or the state that it can't do congestion pricing for Manhattan? Isn't that purely a state decision?
The Department of Transportation granted a waiver to New York to allow congestion pricing. The Department of Transportation could revoke that permission. But as I alluded to earlier when we were talking about other regulations, it would have to follow the proper procedures. Just as the proper procedures were followed in creating the approval, the same proper procedures have to be followed in revoking the removal. Donald Trump can't do that by executive order, which he said he was going to do last week.
A separate issue, we have a viewer who's asking about back in November of 2023, UC President Michael Drake issued statements about intolerance, bigotry on campus. And the viewer is wondering, do you think those policies are now being enforced on all UC campuses?
I'm on one of the 10 UC campuses, so probably can talk most about that, but I can also speak from observation across the country. This year has been much, much quieter at Berkeley, other UC schools, and across the country compared to what it was last spring or even over the last couple of years. Is that because of the policies? Is it because the election of the Trump administration has consumed so much attention? But I do think that there's been a real effort in the University of California, probably other schools, to try to create an inclusive learning environment and to focus on the problem of anti-Semitism. That doesn't mean it's solved. There's certainly still things to be dealt with, but it's a lot quieter this year than it was last year.
This is not about anti-Semitism on campus, but this morning my son sent me an article from the Stanford Daily about Larry Summers' recent appearance. They were doing a pro-con thing dealing with climate policies, and a group of activists got up and shouted down Larry Summers and called him terrible name. Again, I'm not saying this has anything to do with anti-Semitism, but it's related to climate on campus. And it's really interesting because everybody involving the campus community really came out critical about the activists shutting down what was designed to be an open discussion about this and how Larry Summers was treated. And I thought it was very interesting because it was very different than some of the earlier responses to disruptions we've seen on campus.
There is no First Amendment or free speech right to disrupt and shout down a speaker. I send a message to the entire law school community at Berkeley every fall stating our free speech policy. And there's a paragraph about this that says If you don't like what a speaker says, bring your own speaker. Peacefully protest in a non-disruptive way, but you have no right to disrupt. And if you disrupt, you'll face discipline.
Let's see, we have had a number of viewers who have asked, didn't the Supreme Court, in essence, hold that the president is above the law with the presidential immunity ruling?
I think the presidential immunity ruling, Trump versus the United States, is terrible. I think it's inconsistent with the rule of law. What the Supreme Court said is that a president cannot be criminally prosecuted for official acts taken in office to carry out constitutional powers. I think that then says, as to those official acts, the president can't be held criminally liable. Now, the hope would be there'd be other ways of holding the president accountable, perhaps impeachment and removal, if it's an extreme example, perhaps holding accountable those who are violating the law in the name of the president. But I agree with the caller that I think that when I look at terrible Supreme Court decisions in history, Trump versus the United States is one, because it goes, Larry, to what I said earlier. The core of the rule of law is that no one, not even the president, is above the law. And Trump versus the United States says, in some instances, the president is above the law.
Sandy asks, can the Senate or House of Representatives exert any control over an attorney general, Pam Bondi, or any assistant attorney general who acts in the capacity as essentially a personal attorney carrying out um, dictates of the chief executive?
I think it's a great question. Attorneys for the Justice Department are supposed to be representing the United States. They're not to be the personal lawyers of the president. They too take an oath to uphold the constitutional laws. They're not supposed to do things that violate the constitutional laws. What can Congress do? Congress can certainly hold hearings to investigate. The difficulty is with a Republican House and a Republican Senate, how likely is it that they're willing to hold hearings to investigate? The minority party is limited in what it can do in that regard. Also, if the situation where the Justice Department is violating the law, those officials can be subject to impeachment and removal as well. But again, how likely is it that a Republican Congress would be willing to do that? And so what this comes down to is, what do we really have in terms of checks and balances if there's an administration determined to violate the law and even to violate court orders?
There was a lot of attention to the president firing all the U.S. attorneys, but when there's a change of administration, don't the U.S. attorneys switch out anyway? Isn't that typical?
The president has the constitutional authority to fire United States attorneys. There's no doubt about this. Other presidents have done so. President George W. Bush fired a number of United States attorneys. There's the authority to do so. But here's the difference compared to some of the other offices we're talking about. There's no statute that says that a United States attorney can be fired only for just cause. Compare that to the National Labor Relations Board or the Federal Election Commission, where there's a statute that says that the members of that commission can be fired only for just cause. And in 1935, as I mentioned earlier, in Humphrey's Executive of the United States, the Supreme Court said Congress can limit firing of the heads of independent agencies. President Trump has said, and his acting Solicitor General has said, they are not going to follow Humphrey's executor. They believe that the case is wrong. And so, as an example, the president fired a commissioner on the National Labor Relations Board who was supposed to serve until 2028. The president has removed somebody who had the Office of Special Counsel to protect whistleblowers, Hampton Dellinger, saying, I don't care that there's a statute that limits removal. I have the power to fire anybody. And that may be the first of the cases to get to the Supreme Court.
We've had several viewers ask, with the president purging the military leadership of the country and only loyalists being in top military positions, is there any sort of recourse or can the president do that?
The president can do that. And what I'm concerned about is having a Secretary of Defense, Pete Hegseth, who is so loyal to the president. And if he fills the top ranks of the military with those who are loyalists, will we have a military that's willing to withstand and ignore unconstitutional orders? Those in the military take an oath to obey the Constitution. They're not supposed to follow unconstitutional orders. But people in the military are also trained to follow orders. If I were to explain why I'm most fearful, the president's control over the military in this way, the president's control over law enforcement, having Kash Patel, the head of the FBI, finding out that Elon Musk apparently has the codes to the Treasury Department for all money is spent. I mean, these are the things that lead to dictatorial power. And I don't want to sound apocalyptic, but they're the things that make me worry.
Anusha and a number of other viewers ask, and this is sort of the ultimate question of our discussion tonight. If the president does not comply with court orders, um, what happens next?
We then will have a constitutional crisis unlike we've ever seen in American history. It would then be a president saying, I don't have to comply with the constitutional laws. I don't have to comply with court orders. I can do whatever I want. And then the question is there anything that the courts can do on their own to enforce against the president? Probably not. Then the issue would be, would Congress be willing to impeach and remove the president? If Richard Nixon had disobeyed the Supreme Court in 1974 and refused to release the Watergate tapes, the House would have impeached and the Senate would have removed. We're in a very different political climate now. But to go back to what I said a moment ago, if the president can ignore the Constitution and laws, ignore court orders, and do whatever he wants, then no longer are we a government under the rule of law. Then we really do have a dictatorship. And I hope that day never comes. And I hope with all my heart that President Trump ultimately would back down and comply with court orders like every president in history has done.
Jim asks, under what circumstances could President Trump declare martial law and use the military to enforce his personal wishes?
There is no authority under the Constitution or federal statutes to declare a martial law. There is a federal statute that limits the use of the military domestically in the United States. And there is a 1798 statute that would say if there is an invasion of the United States, then the president can use the military to repel that invasion. But unlike some countries, there is no such thing as martial law under the constitutional laws of the United States.
Marshall in Maine asks, can the president legally withhold federal funds from a state if the state's governor doesn't comply with a presidential directive? Marshall specifically asking about whether a state refuses to stop allowing transgender students, athletes to play on girls' teams.
First, conditions on federal money are to be set by Congress, not the president. And if Congress wants to say that states to receive certain federal money have to bar transgender athletes, Congress can do so. But the president on his own can't decide when federal money will be spent. And second, there's a constitutional principle that Congress can't commandeer the states. Congress can't force the states to adopt laws or administer a federal program. You might remember in the Brady Handgun Control Act, Congress said that state and local governments had to do background checks before issuing permits for firearms. The Supreme Court declared that unconstitutional, said it's commandeering the states. And the Supreme Court has said that Congress can't put conditions on grants that are unduly coercive for the states. When Congress passed the Affordable Care Act, it said that every state had to cover within its Medicaid program those with 133% of the federal poverty level, or they would lose all federal Medicaid money. The Supreme Court declared this unconstitutional, saying Congress can't use the spending power in a manner that's coercive against the states. So the answer to the question is the 2 points. First, only Congress can set conditions on grants. And second, the conditions with the current federal money can't be unduly coercive.
Diana asks, with President Trump suggesting he might consider a third term, the question is, what does the Constitution allow? Is it only speaking to two consecutive terms? What would the Supreme Court likely do with Trump attempting to say he would be qualified to run for a third term?
The 22nd Amendment is clear that a person can serve only 2 terms as president. Doesn't matter whether they're consecutive or non-consecutive. From George Washington till Franklin Roosevelt, no president tried to serve for more than 2 terms. Roosevelt was elected to 4 terms, and then that led to the 22nd Amendment to make sure it would never happen again. Unless President Trump suspends the Constitution, using the tools that we've talked about, like controlling the military to stay in power, something really apocalyptic like that. There is no way Donald Trump can serve a 3rd term. My hope is he's just trolling people by saying that, but there is no constitutional way for that to happen.
We have a list of viewer who asks, are we on the verge of a constitutional convention of the states to amend or overturn the current constitution and getting around the standard method of amending the U.S. Constitution, 2/3 of both houses of Congress, 3/4 of state legislatures approving?
The Constitution creates a mechanism where if 2/3 of the states call for it, Congress is to convene a constitutional convention. Then what it proposes goes to the states, and if 3/4 prove it, it's then part of the Constitution. This has never happened in American history. We really have no idea how it would work. Do 2/3 of the states have to call for a constitutional convention about the same thing? In what time period? What if Congress doesn't call the Constitutional Convention? If there is one, how are its delegates to be chosen? All of these are fascinating questions for which we have no answer.
All right. Let's see. I think we have time for one more question. There's so many outstanding questions here. Let's see. We have oh gosh, there was a very good one about let me see if I can find it here. There's so many excellent ones. I'm so sorry. There was one I wanted to ask. It was a really great question, and now I can't find it, unfortunately. But what ultimately is the ability? Oh, I remember now. What's the ability of the president to eliminate departments like the Department of Education? Carter was the big advocate for breaking out from health, education, welfare, the separate Department of Education. Could Trump just say, no, that function will live in another department?
Congress creates the agencies, so Congress can eliminate the agencies. The president can't. Take your example. There was the Department of Health, Education, and Welfare. Congress passed a statute to create the Department of Education. Congress created the United States Agency for National Development. Congress could choose to eliminate it, but the president can't. And let me use the beginning of your question to something we were talking about right before we went on in terms of what can people do? What's the ability to make a difference? And I think at this moment in time, what's so important is for people who disagree with the Trump administration doing is to get involved. There are so many organizations right now that are bringing lawsuits and fighting back to volunteer for those organizations, to financially support those organizations. Individually, there's not a lot we can do. Collectively, there's a great deal that can be done. And I think it's so important that people have their voices heard on this. One of the characteristics of authoritarian regimes is how they silence dissent. And I think that it's key that people who disagree find ways to be heard and get involved with organizations that are bringing the challenges.
Speaking of being heard, we had a viewer who asked about the Associated Press being removed from the pool of potential reporters to cover small groups of journalists. Is that within the authority of the White House?
I don't think so. And the reason is that above all, the government can't regulate speech based on its viewpoint. The Supreme Court has said this so many times. What the president is saying is Associated Press isn't calling it Gulf of America, it's calling it Gulf of Mexico. So we're not going to give the Associated Press the same privileges as other media outlets. There are several lower federal court cases, one in DC, one in the Ninth Circuit on the West Coast, that have made clear that government officials can't deny press privileges based on the viewpoint they take. A couple of days ago, a federal court in Washington said that AP hasn't shown it's an emergency yet, but the judge, a Trump appointee, said, I'm very concerned about what President Trump is doing, and the Trump administration should rethink what it's doing. I hope they will, but if not, I think discriminating against media outlets based on their viewpoint violates the very core of the First Amendment.
Erwin, it's always a pleasure to talk with you. I learned so much in our conversations. I appreciate it, as I know our viewers do, and certainly Judge appreciates your willingness to come on these programs regularly and to talk about constitutional law and the new administration. Thank you very much.
Always such a huge pleasure to talk with you, Larry.
I appreciate it. Erwin Chemerinsky, of course, the Dean, UC Berkeley School of Law. Next Wednesday, March 5th, America at a Crossroads brings Professor of Ethics and Finance from NYU, Michael Posner, in conversation with Madeline Brand. The topic is social media and democracy. Can we reclaim a common truth? That's next Wednesday, March 5th, the usual time, 5 o'clock Pacific, 8 o'clock Eastern, for the next America at a Crossroads. From all of us at these programs, thank you so much for joining us and have a very good rest of your evening.